This contrasts very starkly with what the Second Circuit Court of Appeals found in the challenge to New York's sensitive places restrictions, where the Second Circuit upheld most of the state's sensitive places restrictions using a relatively broad view of historical analogs. They weren't necessarily relying on literal bans on carry at many of the places that existed, as you mentioned here, throughout American history. Instead, they took a much broader analytical approach to it, analogous approach. They relied on other sorts of gun restrictions that existed at the founding era, and even well after that, to uphold most of the modern gun-free zones created by New York in their broom response law. Outside of there was some agreement. I will say that the vampire rule, as you guys have termed it, was essentially banning gun carry, even by licensed individuals, on private property that's open to the public, things like stores or restaurants or something of that nature, which really flips the way that the rest of the country the whole country has historically done this, which is that generally you're allowed to carry unless somebody says you can't by posting a sign. So that you've got a very different approach here in your case in May, where the judge takes probably one of the more narrow approaches to analogs as well. You note that obviously he thinks that analogies don't work for a number of these areas because they existed during the founding and there weren't these sorts of restrictions then. But also he takes it not just on guns being present in a certain location, but specifically on barring people who have this level of training and I guess statistically who are statistically unlikely to carry out crimes. That's how he sort of framed people who get concealed carry permits, right? Because they are largely more law-abiding than the rest of the country, or one of the most law-abiding groups statistically, at least, in the United States. And he sort of frames it as that, like, were there these kinds of restrictions specifically on these kinds of people who both qualify for and have gone out and done the work to obtain a special license. That was the requirement he was really looking for. And that is very narrow compared to some of these other cases, right? And
it's narrow, but it's correct for two reasons. So Bruin tells us in no uncertain terms, and the Second Circuit ignored this, by the way. We argue that in our opposition to the state's motion to stay. But Bruin tells us that when a problem existed in the past, like, for example, armed people carrying in a bar, that existed. When that happens, you actually don't get to do analogs. You have to find a distinctly similar regulation. That's what Bruin tells us. You only do analogs when it's a dramatic technological change or a new societal problem. And that isn't the case for most of these places. Like I said, we didn't challenge nuclear facilities, but we acknowledge that that's an unprecedented societal concern. Nothing like nuclear facilities existed prior to 1900, right? So if we did challenge that, which we don't, the state could, of course, do analogical reasoning and probably pretty stretched analogical reasoning to justify that. But when something existed, Bruin tells us that there's no license to go ahead and do the more nuanced approach, as they call it. And as to the concealed carry permit holders, we presented data both here and in an amicus brief in Hawaii about how law-abiding they are from several different states. And the state is now complaining that that's basically interest balancing, but that's not what we were arguing. So yes, part of the preliminary injunction test, unlike a judgment, is balancing of harms, and it does go towards that. So even though Bruin doesn't have interest balancing, the winter factors for preliminary injunctions do. But anyway, beyond that, the state is the one arguing that, these places have changed dramatically, so we right? But it's only fair, if you're going to argue that, it's only fair to also acknowledge that in 1860s California, anyone could open carry. There was no permit process. There was no restrictions of any kind. Whereas today, there's a pretty extensive process to carry. So if the state's going to argue, and we're glad Judge Carney saw this, if they're going to argue that places have changed, it's only fair to also acknowledge that people who can carry have changed. They're far more vetted today, and that should play a role in it. The modern changes shouldn't only benefit the state; it should go both ways. And I think the Second Circuit, unfortunately, ignored that distinction.
Yeah, I haven't really seen a judge make that narrow of a determination before, as far as what the actual analogy needs to be, including that aspect of it, that these are not just anyone carrying, but people who've obtained a permit, which is a relatively difficult thing to do, and has shown to be, these kind of people have shown to be very law-abiding statistically. So it was interesting to see that, and I do wonder if perhaps that's going to be something that shows up more in these kinds of cases down the line. I mean, I imagine that's what you guys are going to continue to pursue as this case gets litigated, that sort of standard.
Yeah, I mean, if California is not going to let us have constitutional carry, we're at least going to hold them to, if they're going to make us get permits, it should at least work towards our benefit too in our legal arguments. You're limiting the right to carry to a subset of people that can do an 8-hour training course, that can pay these fees, that can wait sometimes several months, which we have another lawsuit about lengthy wait times. But so if you're going to do all that, you can't then talk about what a danger carry is, because only the people you've extensively vetted can carry. And the state, interestingly, we presented all the data in our opening brief and in the lower court here, and in their opposition, which was exceedingly lengthy because we agreed to let them have a longer brief so we could have a longer brief, they didn't even try to rebut the data. They didn't present any counter data saying, oh, actually people who carry commit crimes. Instead, what they argued was that, if you let people carry, it can interfere with other constitutional rights because they'll intimidate people exercising the right to free speech, which doesn't make sense because California is only concealed carry. But anyway, nobody would know you're carrying, and if they do know, then it's a crime because you're brandishing.